Okay, we are back in session. To the road rule. Has more oxygen helped Jim?
It's helped Trevor. And it's helped me too, actually. I went out and sprinted around the outside, and Trevor had a great idea in the meantime.
Well, I was, as we're having this conversation, it seems to me that just a plain meaning of the word road probably makes the most sense in here. And you just Google it, or you can look up a number of different resources and use that as a definition. I happen to be looking at one right now. A road is a thoroughfare, route, or way on land between two places has been paved or otherwise improved to allow travel by foot or some form of conveyance, including a motor vehicle, cart, bicycle, or horse. I'd like to read the one I have.
A wide way leading from one place to another, especially one with a specially prepared surface which vehicles can use.
That's worth.
Is that out of like the dictionary?
Yeah, I just Googled it.
Yeah,
Well,
no, so,
and I guess I just also would offer that, Evan, would you explain what you told me about when there's no definition and how that applies?
Yeah, absolutely. So there's a canon of statutory construction that is employed by courts and would be employed by coordinators, commissions, and the board that says if there is a term that is undefined in statute, you do exactly like Representative Squirrel just said, is you use its plain ordinary meaning, which you can derive from the dictionary. So I did the exact same thing that you both did in the break, which was let me look up the definition in various dictionaries, and the results I received were very similar to the results that you received.
And so the question is, do we need or want to actually add a definition?
Have there been decisions in the past with Act 250 that have defined road, or that we should be aware of as we make this decision?
So, I mean, from the board, I'm sure there have been, because the road rule was, a version of a road rule was previously in effect. However, the committee has heard testimony that there was some problems with that. So I can't recall a case right now that defined road, but I think that the conversation about using dictionary definitions is moving in a positive direction. And I think it would be reasonable for the committee either to say, we'll leave it up to courts and coordinators to use similar definitions, or the committee could just take a dictionary definition that it finds particularly good and just use that.
And Ellen, thank you. Do you have anything to add?
No. We don't define ducks. If it looks like a duck.
yeah. Yeah,
Like a duck.
yeah. I am reminded that in the past we've either referred to it's the plain meaning in the dictionary, and I think on defenses on the floor, but I also think we've put them in before. I think we can get Evan to come with his canon when we're on the floor and explain it. I would suggest that we get off this bubble and suck it up, and we can. Whoever gets that section to report on the floor can just say, well, a road. Remember, a road means is the plain meaning in Webster.
Okay, so then, Evan
can
also brought up a concern about any new development or subdivision which is used twice now on page 8 in the new definition of development.
Yes, so Evan Meenan from the board. So the suggestion was simply just on line 17 to just delete the words "for the purpose of accessing a development or subdivision." And that would still take care of the problem that might occur if a municipality were to improve a Class 4 road at the bequest of a private citizen, and in accomplishing the improvements, it still met the other jurisdictional thresholds in this rule.
So really, we're deleting the whole sentence.
No, because it's still clarifying that the term road includes improvements to Class 4 roads by a private person, even if that road will ultimately be dedicated to a municipality. But it eliminates the requirement that that road have to serve an otherwise jurisdictional development or subdivision. Because at the end of the day, if the development or subdivision is already jurisdictional and you're building a new road to it, that is very likely going to be a material change that triggers jurisdiction anyway.
Right.
So if you're trying to get at these types of roads that aren't going to trigger jurisdiction through some other mechanism, I think it would be a good idea to delete those words that I just read out. If that's the committee's direction.
And so one more time, which is, where are we deleting?
Line 17, the words that we propose deleting would be "for the purpose of accessing a development or subdivision." Just that phrase.
And then,
Yep.
Jim,
I think that would also speak to the concern of Steve Jobs coming up and buying a 1,500 acre parcel and putting one house on the top of the hill. And because that's not gonna be a development, it's just gonna be a building permit issued by his town. And he's gonna have to comply with this. And I think that's a really good fit.
Or billionaire Jim.
Yeah, that one too.
okay, other outstanding issues before we let Ellen go and make our changes.
Only because Steve Jobs.
Is there anyone? Okay, we're finished.
Really? That was Kobe.
Okay, how much time do you need, Ellen?
So, I don't know what the effective date section is going to say.
Oh, yeah. Evan is willing to sit down with you and go through them
Okay.
and update them.
Okay. So, other than
So-
that,
Yeah, Madam Chair, I sent an email to Harvey, Representative Smith, and who's getting better, but his wife is also taking a turn, a little worse. And he wanted to be here, and he was gonna try and make it for this afternoon, because as a result of our discussion yesterday, I thought the vote would most likely occur in the afternoon.
Yeah.
So I'm hoping that we won't vote until the afternoon, so he would have an opportunity if he's now on route.
Okay.
Doesn't look like
For the
Tom.
floor. What's that, Lee?
I said, it doesn't look like Tom's going to be around.
Yeah. Has anyone heard from Tom?
I sent him an email, but he didn't respond, so.
Thank you for reaching out to Harvey.
Yeah.
Okay, so, after the floor. We'll come back. Thank you. We are, Jim,
It's only worth, not only, it's worth noting that Ellen did magic last night
is,
and somehow coerced editing and whatever we call them downstairs into doing this thing either, the first thing this morning, and that's yeoman service. Thank you very much.
yeah,
Yes,
thank you.
Yeah.
Very much. Well, And we acknowledge that
Well,
you're doing
thank
it in
you.
spades, thank you. All right, we will adjourn for lunch,
Till after.
till after the floor.
Commissions. As we discussed earlier, there are 9 district commissions throughout the state that make the initial determination with respect to permit applications. Those district commissions are considered by law quasi-judicial bodies. They're essentially a court, a mini administrative court. Their primary obligation and role is to make decisions based on the evidence presented before them in the context of land use permitting. So that's what they do, that's what their role is. As part of that role, they also have to make certain determinations, including determinations on evidence. They have to make determinations on whether or not an application should be reviewed as a minor application or a major application. And we're going to get into that later on, but very briefly, the distinction between minors and majors is that a minor does not call for a hearing, and a major application has an actual in-person hearing. There are some other ancillary differences between the two and how they're treated, but that's the main distinction. And that's the role of the district commission. All of their decisions are appealable currently to the Superior Court Environmental Division.
For members of the district commission, are the rules forbidding, for instance, ex parte communications apply? It's like an adjudication, and all the discussion has to be in a public forum.
That's correct. Yeah. So the way that we get there is that Act 250 currently incorporates the Administrative Procedures Act, which includes provisions for both public hearings as well as for ex parte communications.
Okay, thanks.
Sure. So we can get the next slide. Okay, so the criteria. You can go to the next slide. So there are, as you all likely know, 10 main criteria. A number of those criteria have sub-criteria, so there's a total of, I think, 32 criteria. We're not, unless there are questions about any of the criteria specifically today, we're not going to go deep into them because we could very likely spend many hours on each. But very generally, so we've got the natural resource criteria, air and water, water supply, impacts on existing water supplies, soil erosion. Transportation safety and congestion is 5. 6, impacts on schools. 7, impacts on municipal services. 8, wildlife habitat, historic sites and aesthetics. 9, impact on growth. 10, conformance with local and regional plans. So the commissions, the district commissions and the Superior Court on Appeal are essentially, their charge is to take a look at all the evidence before them and make a determination that the evidence supports a positive finding on each of those criteria. If the commission finds that each of the criteria have been met, they will issue a permit with conditions. If they find that even just one criteria is not met, they will issue a denial of the permit. Unless for one reason or another the applicant can fix the shortcoming.
Is that on the process of getting to either an issuance or a denial, is there a dialogue that allows verification of the application and issuance of a permit with conditions, that sort of thing?
Sure. So if there were a significant dialogue to happen, it would be during a major process, during the hearing. Essentially, there's opportunity to respond to evidence, cross-examine evidence, submit your own evidence if you're a party.
Can you say something about the 10 criteria and how they compare to all the criteria that lead to a designation? So for instance, one of the questions that we're going to end up facing is, if you're in a designated area, might you sort of have, in a way, pre-permitted on a number of things because they've already been considered as in the process of earning that designation? So I'm wondering if all the designations mean that all 10 criteria. Any designation means all 10 criteria have already been examined. Maybe they get re-examined in a more particular way for a particular application, but do we ever lose examination of any of the 10 criteria if we go into the designated process instead?
Yeah, that's a very good question. And the short answer is that the designation process, and I think you're referring to the 5 state designated centers, designated downtowns, growth centers, new town developments, neighborhood development areas, and village centers. They're an array of designations for which each have certain benefits. And the short answer is that it's not a zero-sum game. The designation process does not look at all 10 criteria. It looks at some, but it's not as if the designation process looks at the Act 250 criteria and says, okay, this is how we're going to deal with transportation, this is how we're going to deal with public infrastructure. It doesn't quite work like that, and there are some criteria, and I can't today provide you with a definitive list, but there are certainly some criteria that are not addressed in the designation process. Sure.
But that is moving now also, so there is conversation
Another
about.
flag.
Yeah, another flag, yeah.
Burden of proof. So generally speaking, the applicant always. So now we're talking about what evidence the commission is going to be looking at, and who bears the burden for which criteria. Generally speaking, the applicant is always going to have the burden of production. The applicant is always going to have to submit enough evidence to the district commission so that district commission can make a decision one way or the other on each of the criteria. The applicant retains the burden, the final burden of proof or persuasion with respect to most of the criteria, 1, 2, 3, 4, 9, and 10. If there is an opponent to a project, that opponent would bear the final burden of persuasion with respect to criteria 5, 6, 7, and 8. And once the commission reviews all of the evidence, takes all of the testimony that it deems necessary, it will ultimately issue a decision. If the decision is issued and a permit is issued, the permit will always include conditions that help the project meet the criteria. So we can move now to the next slide. So Act 250 is a citizen-based project review process, as you all know. We can go to the next slide. And part of that process relies on input from other entities besides the proponent of the project or the developer. And there's a couple of different mechanisms that Act 250 has to get at that additional information that might be out there. One of them is by way of party status, and we can move on to the next slide. Party status is the legal mechanism that allows entities to participate in the fund and to submit evidence and to cross-examine evidence and to act as a party in the proceedings. It's the law. Act 250 is based on this idea of citizen participation. And ultimately, if party status is done in a way that is, if a broad enough approach is taken to party status, it allows commissions to receive as much information as they deem appropriate. And ultimately, if parties participate in a constructive way, at least theoretically, that should avoid delays and appeals and remands and the like in an effort to make the process as efficient as possible.
Amongst parties, how can you characterize how many parties are actually there? It's a citizen who comes in and just voices sort of in non-legal language, a concern about a project versus a more formal representation by lawyers in the process.
Sure. Yeah, I think we're going to hit on that in a couple
Okay.
of slides. So
Sure.
and if I don't answer your question, remind me and I'll try to hit it again.
Let's keep going. Thanks.
So, the current Act 250 allows for certain statutory parties. These are parties by right. They're automatically parties. They may participate, they may choose not to participate. Those parties are the applicant, the landowner, if the landowner is not the applicant, the municipality in which the project is located, and municipality and regional planning commissions for that municipality. Municipalities and regional planning commissions adjacent to the project, and any state agency that might be affected by the project. And before we move on to the next slide, I want to just touch on this piece, because this is important. Generally speaking, the state agencies that we might see participate in the project are the Agency of Natural Resources, the Agency of Agriculture, Department of Historic Preservation, and Agency of Transportation. Thank you. There are others, but those are, I would say, the four most common players in Act 250 permitting matters, and they all provide invaluable resources to the Act 250 district commissions by addressing certain issues that may not be obvious to the district commissions concerning their areas of expertise. Among those four agencies or state entities, I think it's fair to say that the Agency of Natural Resources probably plays the most significant role with respect to the 5 natural resources criteria. And they often participate by way of reaching out to the applicant sometimes before an application is filed, sometimes during the application process, sometimes during the application process itself before a matter goes to the hearing. And the agencies really act in many ways as experts for the state, so that they can provide feedback to certain aspects of any given application, and then ultimately they can provide that evidence to the district commission. So it's an important process that plays out, and there's oftentimes a lot of back and forth between the agencies and the applicants, and sometimes I don't think that's recognized by folks who are not intimately involved in the Act 250 process.
How is it that A&R, for instance, will be aware of a project before it's actually had an application filed? How do they get
Yeah, so that's a good question. There's a couple of ways. Number one, there might be an ancillary permit. So for instance, the agency might be in the process of reviewing a permit application for a wetland or a stormwater project or a wastewater program, and they will know that project will trigger Act 250, and so they can start working with the applicant pretty early on while the applicant is obtaining those ancillary A&R projects or permits. And the other way that comes to mind is, especially for the more seasoned consultants, before an application is even filed, it's more than, and the project is known to have some concerns, some natural resources concerns. It's more than likely that the consultant will reach out to A&R staff to discuss what the issues might be and to see whether or not there might be a solution to the problem even before an application is filed. And so when the process works like that, you end up with a better application, and you end up with a better process at the end of the day, because the application has already been vetted, and it's more complete, and it makes it easier for the district commissions to review. Yes, and so there are also there is a mechanism called a project review sheet. Whenever a developer is in the process of going through an ancillary permit, so for instance a stormwater permit, that triggers the need for a Act 250 district coordinator to review what's called a project review sheet, which is essentially a request for a jurisdictional opinion. When they see the project review sheet, which includes a brief description of what the project is, the district coordinator will make a determination as to whether or not the project needs an Act 250 permit as well.
And just if I may, that involves also the permit specialists who work for A&R. So when somebody needs a wastewater permit specifically, a PRS will be filled out, and that goes to the coordinator, and then there's a collaboration going forward on jurisdiction.
So if you're not one of these statutory parties, how do you become a party? How do you get party status? And the statute that governs party status says any person who has a particularized interest protected by this chapter that may be affected by an act or decision by the district commission will be a party. The standard that's developed out of that provision over time is that an aggrieved person need only show a reasonable possibility that a decision on the proposed project may affect a person's particularized interest. So that's really what the district commissions have to look at with respect to a request for party status. In practice, what happens, an individual might become aware of an Act 250 application either by way of word of mouth or by receiving notice, either actual notice in the mail if they're an adjoiner, or by reading about a proposed project in the newspaper, or by seeing the notice in their town office. If a person feels like they are aggrieved and want to participate in the process, they have to file a petition for party status, either directly with the district commission in advance of the first hearing, or it can be done orally at the first hearing. The commission will review the petitioner's concerns and make a preliminary determination on party status. So, and more often than not, and I don't want to say always, but more often than not, the commission is likely to grant preliminary party status, which grants an individual or an entity the right to participate at the hearing. At the end of the hearing, the commission will revisit its decision and make a final determination as to whether or not this individual or entity should have been granted party status.
So I'm thinking about something like the state's policy around having high quality waters where you can swim, fish, all that kind of stuff.
Sure.
If I'm right next to a proposed development, you would be in a butter, so you get party status, right?
Adjoiners get notice. They don't automatically get party status though, and that's sort of a misnomer.
Okay.
I think there's a number of people who think it's automatic party status, and that's not quite how it works.
Okay, so notice, but not necessarily party status. So would I need to say, I'm concerned, I swim in this, I fish in this,
Yes.
and this could affect the quality of the water, so that would be.
Absolutely, and more likely than not, that would be a sufficient petition for party status. So the elements are the red underlines in the first one. They're you're a person. You've defined what your particularized interest is. You fish, you swim in the river, and you'd be affected, at least presumably, by the project. So I think that you would probably pass the test to participate.
And he would have to specify which criteria.
Correct.
Okay, and how closely, if I'm a mile downstream, can I still come forward?
You can. If you use that water and you still have the particularized interest and you're affected, you can still make that argument. And I think the piece that the commission's going to be concerned about at some point, depending on how far away you get from the project and how often you use it, that's going to be maybe the defining factor. But if you're using that water source, the water body regularly, or even once in a while, the commission is more than likely going to grant party status.
Does residency make a difference?
No.
So you could be visiting. That's what I'm talking about. With regard to, you're coming over the border from New York to fish in that part of the Walloon-Sac or the Battenkill, doing it regularly during fishing season.
So, yeah, you're not a Vermont resident.
Not a
You
Vermont
come
resident.
regularly. You know, I don't want to get into hypotheticals
I
too
understand.
deeply, but
I
I think that would be a good case for party status, in my opinion.
Oh, and I asked about water because we talked about water is being held in public trust and shared by everyone, so I didn't know how far that connection through water and shared interest would reach.
Yeah, yeah, and I think the chair was also making a really important point that I just want to drive home here. So any person or entity that is requesting party status does have to be specific about which criteria they're requesting party status for. And because you're granted party status on criteria 1 and 4 does not mean that you are granted party status on transportation criteria 5. If you want to participate in a certain criteria, you must seek affirmatively party status for each of those criteria that you want to participate.
And I was just going to say, if you do gain party status, you can then appeal, but again, you have to appeal based on the specific criteria that you were given party status.
That's right. And then we just sort of highlighted the elements again in this slide, which we just went over. Any person, and any person is not just a person, it's also an entity. It could be a business, it could be a nonprofit corporate, a nonprofit entity.
It's the any person / corporate definition we've all wrangled with.
Particularized interest and affected by the project. And I've already went over final party status. Okay, next slide.
If you did obtain final party status, that's what mean you participated, but then with this, in a way, we're gonna, I don't know what they do, they say we're going to now disregard the information you brought because you actually determined you weren't a part.
That's correct. And the other point is, if you were denied final party status, you lose the right to appeal the decision, except you could appeal the decision on final party status. So the application review process, this is sort of like the nuts and bolts of how the process works.
Very bare bones.
Bare bones. Yeah. I mean, there's a lot to the process. This is the bare bones. So an application, presumably the developer has spent some time drafting a complete application with all the necessary exhibits and the check for fees, and submits it to the district office. The district coordinator reviews the application to determine whether or not it's complete and sufficient to be reviewed by the district commission. That is supposed to happen within 7 days. If the coordinator finds for one reason or another that the application is incomplete, that can be appealed, and it's considered a jurisdictional opinion for purposes of appeal. That does not often happen, but
usually what happens is the coordinator sends an incomplete letter to the applicant and says you need these things to be added to your application to make it complete.
That's right. Once the application is deemed complete, the commission has 10 days to determine whether to treat the proposed project as a major or a minor. And again, the distinction there is the minors don't have hearings. They have a comment period, but no hearings. A minor can turn into a major if someone requests a hearing, or if for one reason or another the commission on its own decides, hey, this should really be reviewed as a major. No, that's fine. So either minor or major. If an application is to be reviewed as a minor, notice and the proposed permit are mailed and published to all of the entities and people that are required to get notice by statute. There's a 20-day comment period during which an entity can request a hearing, and then the commission would make a decision on that request. If no hearing is requested, a final permit is issued thereafter. If a hearing is requested, we move into the major process.
Although a commission can deny a hearing.
Do you
Request for hearing.
also have to, if you're asking for a hearing, do you also have to be asking for party status?
Correct. So,
If you're, sorry,
Oh, go ahead.
if you're not given party status, are you unable then to call for the hearing? Because you can say, well, you don't have party status, so we hear that you want a hearing, but we still don't think we need one, and the process keeps going.
yeah, so they're two separate determinations ultimately, and the commission will likely look at the issue of whether or not there should be a hearing first. And as part of that decision, the commission is going to be looking at some of the issues that are raised, assuming the person requesting a hearing raises the appropriate issues. Those are going to be reviewed and weighed as part of the decision as to whether or not a hearing should be granted. The commission will then take up the issue of party status more than likely after a decision on a hearing is made. That's a good question. So, provided the application is being reviewed as a major, notice is mailed and published in the newspapers within 10 days of filing a complete application. There must be a hearing or a pre-hearing or site visit within 40 days of filing a complete application. Ultimately, there'll be a hearing. The hearing is, more often than not, a morning or an afternoon or sometimes an evening. On occasion, hearings last for more than one day. They might be 2-3 days, but that's somewhat infrequent. It happens from time to time. Once the hearing itself is adjourned, the commission might determine, or I should say more often than not, will determine that it needs additional information. It will issue what's called a hearing recess order within 14 days of the final hearing. And that typically asks for more information. Applicant, can you provide XYZ? Can you, or neighbor, you express concerns on this. Can you please clarify your position? Once those items that are requested are filed back with the district commission, the other parties will have an opportunity to respond to those items that were produced by the other parties. And once all of those items have been filed with the commission, and the commission had a chance to review the items, the commission will issue a permit, or assuming that it is willing to issue a permit and not denying the project, it'll issue a permit as well as findings of fact and conclusions of law. We can go to the next slide. So this slide I included, I have a sense that you all likely know what happens at a hearing, especially after our discussion just now.
Yeah, and senators have lots of hearings.
Yeah, exactly. Senators, you all have lots of hearings. So, it's an opportunity to present evidence, cross-examine witnesses. It's an opportunity for opponents of the project to ask questions. It's an opportunity for the commission itself to ask questions on clarity and so forth. But it's a hearing, not unlike any of the hearings that you've been to.
Is there back and forth so that maybe through the chair or whatever, but that if neighbor A says, I'm worried about this feature, that the applicant is allowed to then respond to that concern so that you work your way through some of the issues in real time?
The design of these hearings are relatively informal, and so there might be a little bit of variability between commissions and how chairs of the commissions like to handle their hearings. But I would say more often than not, it's a relatively informal process, and that sort of dialogue could be helpful. So I would imagine more often than not, it would be allowed. So long as you're staying within the confines of the criteria that are issued, right? Commissions wouldn't want to explore items that are not among the criteria. It's a relatively small universe of issues that can come up. So decisions and permit, applications are either approved or denied, and whenever they're approved with conditions. And like I was saying earlier, major decisions will include both the permit itself and the findings of fact and conclusions conclusions of law. All of those items, the findings of fact, the conclusions of law, the permit itself, they're all appealable to the Superior Court. Environmental Division, again, that's something, big picture we want to flag for you. If a permit is denied, it can be appealed to the Superior Court. Permits run with the land. They don't just live on for the duration of the construction or operation of a given project. They run with the land indefinitely. Flag, that's something that the House is looking at, maybe making some changes to. We can go to the next slide. I think this might be the final or second to last slide that we have in the PowerPoint. This just talks about what's appealable, and you know the big picture here is any decision by the District Commission is appealable to the Superior Court Environmental Division, and the court looks at those appeals de novo. Big flag on that one. There might be some changes proposed. The idea is, for those of you who may not know, a de novo appeal allows the reviewing body to look at the case brand new, as if there was no decision issued below. The Superior Court Environmental Division on appeal will take brand new evidence, and there is no deference at all to the decision that the commission may have issued. So it's a brand new trial. Just one point of clarity though. If an appeal is taken on a permit, it's typically taken on only one or at most a handful of criteria. So it might just be criteria 1G, wetlands and traffic concerns that a party has. And so the appeal will be confined to those two criteria. The court won't open up the entire issue, the entire decision that the commission made. Only the criteria that are appealed.
So it's de novo, but only for the criteria?
That's correct. That is correct. I've just listed a bunch of resources here. We don't have to go through these, but we have quite a few resources on our website. If any of you have extra time and are interested in learning more about Act 250, you should feel free to.
Extra time.
Yeah.
It's like extra money.
Senator Perry.
And so if there are, I was going to say, Chair, if you don't have anything to add, maybe we open it up for questions.
Oh, absolutely. Yeah. Clarifications, questions, statements. I did want to go back to your question, Senator McDonald, about the difference between 1970 and now in terms of how many applications come from, and if this is not what you asked me, please let me know, but how many applications come from out-of-state corporations? Is that the question?
Yes.
Okay. And I gave you an answer which is my belief. On the other hand, I have not done any research to understand that. So I still feel as if, based on what I see of applications, that the majority are Vermont-based companies. But that doesn't mean there aren't an increase also in corporations.
I made a list of.
Thank you.
Which was just a stream of businesses that operate in Vermont today. And then my question was, if you look for these businesses 50 years ago, how many